Welcome to our third edition of Special Needs Jungle in Conversation. Today we are lucky enough to be having a conversation with Steve Broach. Steve is a barrister in public law and a SEND parent hero, and of course a regular Special Needs Jungle columnist. He has a particular interest and expertise in health, education and social care, with a focus on disability and children's rights. So given all the confusion at the moment because of the changes brought about because of coronavirus, we have been inundated with questions for him. We're very grateful to you, Steve, for agreeing to carve out a little bit of your very busy schedule to talk to us.
A real pleasure.
We've had so many questions that what we've had to do is to merge some of the themes from them, because Steve doesn't really want to talk about any cases in particular, and we're hoping to then we can answer as many questions as possible by doing that. So the first question we've got for you is a very, very general one. It's about how the legal landscape has changed for children with SEND recently.
Well, there have been some significant changes as a result of coronavirus. Of course, it's changed everything, including the law, and the response to the pandemic from the government has been two key changes in relation to SEND. First of all, the Secretary of State has issued a notice, which he's allowed to do under the Coronavirus Act, which changes the key duty in Section 42 of the Children and Families Act. In fact, that's two duties, one on the local authority to secure all the provision that's in children and young people's plans in terms of educational provision, and one on the clinical commissioning group to arrange the health provision. And that Section 42 duty is the absolute touchstone of the legal scheme for children and young people with SEND, because it's the guarantee, it's the entitlement to the provision that's in their EHC plans if they have one. And to change that duty, in my view, is a very significant thing to do, because it really does take away the right to support. And what's happened as a result of that notice for the month of May is that instead of having a right to the support, local authorities and CCGs instead have to use reasonable endeavours to secure or arrange that provision. Now, a reasonable endeavour, as the term suggests, is an endeavour which is reasonable. It means taking reasonable steps to make things happen. So clearly, as the guidance says, that doesn't mean do nothing, but at the same time, it's obviously not the same as an absolute right to have the provision. And there will be situations where local authorities and CCGs can properly say, well, we're not able to secure or arrange that provision because it's not reasonable for us to do so, having regard to the other pressures on us, in particular in relation to the virus. And so that does mean that there's a lot more leeway for local authorities and CCGs not to secure or arrange that provision. So that's the first big change. Section 42, this key touchstone duty being downgraded to a reasonable endeavours duty. For the month of May, for sure, at the time we're recording this, of course, we're waiting to see what happens in June. The Secretary of State can make a notice every month under the Coronavirus Act if he chooses to do so, if he thinks that that's appropriate and proportionate. That's the test he has to consider. And if he does think that it's still appropriate and proportionate to have that notice issued, he will no doubt do so very shortly, and it would then cover another month for June. So we wait to see what happens in that respect. The second big change has been the amendment regulations. So those regulations came in at the same time. They last until the 25th of September. So they're going on through the summer unless the Secretary of State changes them. And what they do, in short, is change all of the timescales for completing various steps in the EHC process, from the beginning, from the point of assessment, right the way through to if the family were to succeed in a tribunal appeal, the timescales for complying with a tribunal order. And the way the regulations work is they say if the coronavirus exception applies, then instead of having to do things in a set time, the local authority has to do them as soon as reasonably practicable. So there's that reasonableness concept coming in again, creating that opportunity for a local authority to say it's not reasonable for us to do it in a set time, but we will still do it as soon as we can, in essence. So the regulations work a bit differently to the notice. The notice is general, applies generally. The regulations only work and only operate if in a particular case it's not reasonably practicable for the local authority to do things in the specified time. So it's supposed to be very much a case-specific decision. But again, it does take away rights. It takes away an absolute entitlement to have things done quickly, which is so important for our children and young people, of course. So those are the two big changes. There are lots of other changes to the legal landscape that we might touch on around social care, for example, as we go through. But the two big ones for SEND are those two. And the one important bit of context I think we need to recognise is that these changes are happening in a SEND landscape where a number of local authorities and CCGs are not complying and haven't been complying with legal duty and have been seriously criticised by the inspectorates for not complying with the law for some time. And so it's not like we've got a perfectly functioning system where the law has been relaxed. We've got a system that is creaking at the seams in many places at best, where the law has then been relaxed. And so it's understandable, I think, that a number of families and organisations are very concerned about these changes, because of the context that they're taking place in. So that's the bit of context that I think needs to be borne in mind, and hopefully the Secretary of State will bear that in mind when deciding whether to issue the notice again in June, in July, in August, and then particularly, of course, in September at the start of the new academic year.
So I think a lot of parents don't understand what they have left in their toolbox. And particularly, as you say, it's quite a dysfunctional system. So what exactly does reasonable mean, and to whom? I mean, what is reasonable to me may not be reasonable to them. I mean, as we've just been seeing with what is reasonable to Dominic Cummings isn't reasonable to the rest of the country. So can you explain what reasonable means?
Well, it's a very difficult legal term to define precisely, and that's part of the reason to have it, of course. And the guidance the Secretary of State's issued doesn't really define it. And to be fair to the Secretary of State, I don't think you can define it, because the essence of reasonableness is that you take account of all the circumstances. So it requires a balance between lots of competing interests, lots of competing priorities. And so there's no doubt that the Secretary of State and the guidance and the scheme still recognise that children and young people with SEND are a priority. But instead of being an absolute priority, because you have to do it under the law, you can now balance. The local authority, the CCG, can now balance the need to secure that and arrange that provision with other factors like responding to the virus. And the guidance suggests, and I think it's right, that the more important the provision is, and the more damaging it will be to the child or young person not to have it, the less it will be reasonable not to do it. Does that make sense? So there's a sliding scale taking into account both the factors, if half your workforce is off sick as a result of the virus, that's obviously highly relevant, but then so is it relevant that it will be seriously damaging to the child or young person not to get the provision. So the second part of your question, Tania, was who gets to decide? And the answer to that is always the public body that has the duty. So the first instance decision about whether something's reasonable or not is for the local authority or the CCG. And they'll be entitled to say, we've considered the matter, we've looked at the guidance, and we've decided it's not at the moment reasonably possible for us to secure this provision. Our reasonable endeavours do not allow this to be made. If you want to challenge that, the remedy there will be judicial review. This is not something that the tribunal, which has obviously gets a lot of attention in our world, the tribunal's got no jurisdiction at all to look at issues around Section 42 and complying with the duty to secure or arrange provision. The tribunal's job ends at the point it's made orders about the contents of the EHC plan in that context. So at the stage where you're looking to deal with actually getting the provision that children and young people need, remedy is judicial review.
So basically, there's no free route now left for a parent to go. I mean, you can, in theory, go to the tribunal for free. You can complain to the LGO for free. You can't do that now. You can't go to tribunal. So there is no, for a judicial review, you really do need a solicitor to help you.
Yes, I think that's an entirely fair comment. So just to unpick those various options, the tribunal is not relevant because the tribunal can't do anything about complying with the duty to secure or arrange the plan. The complaints process is still there. There's a statutory complaints process for local authorities and CCGs. Different local authorities and CCGs have adopted different approaches, as I understand it, to how they're dealing with complaints. But as you say, Tania, the big point is that the top of that process is the local government ombudsman or the parliamentary and health service ombudsman. And certainly the local government ombudsman isn't in business at the moment. They've shut up shop for the duration of the pandemic, and they are not available to deal with complaints at the moment. So that independent body that's there to deal with complaints once they've gone through the internal stages isn't available to families. I think that's really troubling. I think that's really concerning as to whether that's appropriate, frankly. I can understand the reasons that are given that it's not appropriate at the moment for complaints to be progressed because of the pressure on local authorities, but it does leave a big hole in the accountability framework. So yes, you've got judicial review. So what is that? I mean, how does it work? It's probably worth me spending a moment on that now, because as you say, it's not free in the sense that I would never suggest that anyone would go to the High Court on an application for judicial review without expert lawyers supporting them. And even if you can get expert lawyers to support you for free, which is not impossible in certain situations, the real concern is how do you pay the other side's costs? Because the general rule in our legal system, not in the tribunal, importantly, but in the civil courts, is that whoever loses pays everyone's costs. And so you can expect, if you judicially review your local authority and that claim fails, that not only have you got to pay your own lawyers, unless you've come to some arrangement with them, you will have to pay the bill for the other side's lawyers. And they've got no interest in making it free or cheap for you at all, have they? In fact, quite the opposite. So the way in which most judicial review claims will happen is via legal aid funding. And that's still what pays for most of my work. And legal aid is available always for judicial review in principle. So judicial review is in scope for legal aid. And the big question is always going to be the means test, the financial test that's applied to see if the person qualifies. And many parents of children and young people with SEND won't qualify because the bar is set very low. But lots of children and young people themselves will qualify. And so what you need to do if you're concerned about these issues and want legal advice is see if you can get legal aid in the name of the child or young person. Now that's not necessarily straightforward, but it's worth exploring. And on my blog, Rights in Reality, there's a list of solicitors. So if people search Rights in Reality solicitors, there's a list of some of the solicitors in our area, the ones that I've worked with over the years that I know offer a reasonable standard of service, essentially. It's not the longest list, but it's more than a couple. You know, there's a number of firms that you can try, and the solicitors are the people who will be able to tell you what the position is on legal aid, and it will be necessary to explore that. If you can't get legal aid, increasingly there are other options, and so there's a website called Crowd Justice, which allows people to crowdfund to get legal actions up and running. That can be very useful, particularly in the early stages of litigation, where you want some initial advice or you want a letter sent, so you can get crowdfunding support. But it's a lot of money is going to need to be raised to fund a whole judicial review. I'm not saying it's impossible. You're probably, though, looking at cases that affect a larger number of people, policy-type challenges as opposed to individual cases. But it's worth looking at whether crowdfunding might be an option. Sometimes there's the possibility of getting funding from insurance policies, worth exploring that as well. But what I would say is get advice from a specialist solicitor as soon as you can, even if that involves a bit of time ringing around or emailing a number of firms. I've never known families take advice too early, because if you go early and get advice, you may well be told it's too early. That's fine, you've got other things to do. But I've known so many families take it too late, and nothing makes me sadder, frankly, than being asked to advise on a damages claim after the event, when there's been perhaps years of failure to provide the right support, when actually if it had come 2 or 3 years earlier, we could have brought a judicial review to get the support that the child or young person needs. So this is not me trying to drum up business. You'll find when you go to the firms that they're all incredibly busy, and it will be hard to get someone to take your case on. There's no shortage of work for people who work in this area. But what I can say is that it's not helpful to wait to get advice. And there's also strict time limits on judicial review. You have to bring the claim promptly and no later than 3 months from when the grounds of claim arose. So you can find yourself out of time as well. Those time limits can be extended, but it all just gets more complicated. So the simple message is get advice early if you're thinking that you might need to bring a claim.
That's really, really helpful advice. Thank you. Just to help clarify a little bit, is it possible to summarise what educational rights children and young people with SEND do actually still have right now, and how they might differ between a child who has an educational healthcare plan and perhaps a child that doesn't?
Sure. Well, the short answer is every right they had before coronavirus, except from the ones I've just discussed. So try and be a bit more helpful than that. Well, I should plug my book as well, of course. So if you look at In Disabled Children, a Legal Handbook, we try and break down all the key rights and entitlements, and the chapters of the book are available free of charge on the Council for Disabled Children website. So you don't have to physically buy or buy the ebook, though of course we'd love it if you did, and you get all sorts of extra resources from Legal Action Group. But the core chapters you can get free. So you can look at the education chapter, and that will give the answer to that question. But in short, one of the things that's quite interesting actually about the Coronavirus Act is that it created a power for the Secretary of State to disapply or modify quite a lot of bits of law. And he hasn't done that for anything apart from Section 42. So all the other things he could have taken away or changed, he hasn't. So that includes, for example, very importantly, Section 19 of the Education Act 1996, which is the duty to provide education otherwise than at school. So for any child who's of compulsory school age, this is any child, not just children with SEND, who's out of school and not getting education, for any reason, there's a duty to provide suitable education otherwise than at school. So that's obviously directly relevant to the situation that children find themselves in now, particularly those who haven't got an EHC plan. Something should be provided by the local authority in discharge of the Section 19 duty. Now, for many children attending mainstream schools, that will be follow your curriculum at home in the way that the school is recommending. But of course, schools continue to have the reasonable adjustments duties under the Equality Act as well. There's been no change to the Equality Act at all. So what's provided at home will have to be adjusted and adapted to the needs and requirements of disabled pupils too. So that's two key points to flag.
Are there any guidelines around what should be provided? Is there a set amount that should be provided?
The rule is, and this is again really interesting in the current context, under Section 19, local authorities are not allowed to take account of their resources when they're deciding what provision to make otherwise than at school. There's an old landmark case called Tandy that establishes that, I think, in the 1990s, possibly even the 1980s. So we've known that for a long time. And that means that the provision otherwise than at school should be essentially what the child needs. So if a child is very unwell, for example, and can't manage a number of hours of education a week, then it can be a very small amount of education. But otherwise, the assumption is, in my view, that it should be full-time, i.e. what they would be getting at school and what their peers are getting. So it should be relative to their age and stage in terms of the provision that's made.
So if local authorities are trying to apply a blanket policy, then actually that's not right.
Blanket policies in our area are almost always going to be very difficult for local authorities to defend, because even if they've only got a power to do something, you know, the difference between powers and duties being so fundamental, that the power just being a may, you may do it, and the duty being a must or a shall. If it's only a may, if it's only a power, they still have to think in every individual case whether or not to do it. And so a blanket policy of we don't do this here, or this isn't available, or even saying this isn't available to this group at all, is going to be really difficult to defend if someone challenges it, because the whole legal framework is premised on individual case decisions and the exercise of judgment by local authorities. But yeah, another area that's still in force that's quite important, I think, and this is going to be very relevant in June, is the school transport duties. There's been no change at all to the school transport duties. So if you were an eligible child when lockdown happened in March and you were entitled to free home to school travel, you're still entitled to that now. Of course, if your school's closed, practicalities is that are very obvious. But once your school reopens and you're allowed to go back, the travel arrangements need to be made in the same way as they did before. And everyone watching this, I'm sure, will be aware of the mess that we've got in terms of the different ages and the law being very different for post-16 and for under 5s. But for that group of children who are of compulsory school age, that core entitlement to suitable home to school travel arrangements is still there. That's another one the Secretary of State could have changed, but hasn't at the moment. And finally, just on the review, and these are obviously only a few highlights, Section 43 and 44 of the Children and Families Act haven't been touched. So that's the duty on schools and colleges to admit children and young people when they're named in EHC plans. And the annual review duty is still there as well. So the timescales for annual reviews have been relaxed if the coronavirus exception applies, but there still has to be an annual review. And that's obviously right, because otherwise the plan gets out of date and it's useless. So in many respects, and the guidance fairly says this as well, it's business as usual. Unless there's been a change, an active change through the notice or the amendment regulations, and in relation to adult social care, there's been a lot of changes. We should come on to that. It's the same as it was before.
You mentioned transport. I think a lot of parents have been told things like, you will have to provide transport for your child because, social distancing or whatever, we can't provide it. We can't give you a taxi. We can't provide a bus. So a lot of parents have been told that they're going to have to get their own child to school if they previously had a taxi. What can they do in that situation?
In broad terms, and of course, as with everything in our area, you need to look at the individual facts. But in broad terms, that's not right. Because if they are eligible children, which means that they live too far from school, where the school's accepted to be the nearest suitable school, or they can't reasonably be expected to walk to school by reason of their SEN or disability, then, and if they're accepted to be eligible children, and if they were treated as eligible children before, then nothing's changed. And so if the method of getting that child to school before lockdown isn't available anymore, the local authority will have to find another method. And that method can't be, you've got to take them yourself. That's not a discharge of the local authority's duty. So how they do it is up to the local authority, subject to judicial review if the method that's chosen is unreasonable, essentially. But to say, no, it's over to you is hard to understand in legal terms.
I think some have been offering money as well.
Yeah, that's what I was going to say.
Same thing.
Yeah, it's clear in the guidance, and I think in the case law, that providing a personal transport budget is a way of discharging the duty to arrange homeschool travel. But it's never been understood, in my view, that you can make a family do it that way. I think it's lawful to have a policy which allows for personal transport budgets. This is for children of compulsory school age, of course, because if you're dealing with the ones who are older or younger, then because there's no absolute duty, you probably can offer a budget. That was what was happening in the Leicestershire case that went to the Court of Appeal earlier this year. But for the compulsory school age children, it's certainly my understanding that the budget would have to be a choice for the family. And it's a bit like in social care. If you're getting a social care direct payment, you can't be made to have a direct payment. You can say instead, I want a service. You've got a right to support. You can choose to have a direct payment, but you can choose not to. So I think there's a lot of confusion about this, and these grey areas will probably need to be clarified through litigation. But the short point that I would say families should be pushing back on is it's your job, local authority, to make this happen. If you want a personal transport budget, great. You want to be paid to provide the transport. But if you don't, if that's not convenient, if that's not something that can fit in with your other responsibilities, or if you just don't fancy doing it, frankly, I don't see why you... Well, I mean, that's if it was a situation where you don't have a car, then that's literally irrational, isn't it? That's perverse in the strict sense, the strict legal sense, because how can you then do it? And those kinds of issues are very suitable for judicial review. That's the kind of standard that the administrative court will be applying. If it's not as obviously irrational and perverse as that, then you're into, you know, a more fine-grained kind of decision. But the principle that it should be a choice, I think, is still a really important one.
So a lot of parents are now going to be facing having updated risk assessments. What fears are, and things we've been hearing, is that schools may say, well, we've done a risk assessment and we can't support your child in our school, so they're going to have to stay at home. And in fact, I know that this has been happening for some children who are not only SEND parents, but also key workers. And they've had to take annual holiday because the school won't have their child. What can parents do when they disagree with a risk assessment?
The risk assessment process is, as far as I can tell, entirely extra statutory. By that, I mean, it's not in law. I'm not saying it's unlawful, but it's not something that's in any of the acts. It's a mechanism, it's a policy construct that comes from the guidance. And it's the Secretary of State trying to balance and work out how to best manage the fact that our children and young people need to be in school, but they also need to be safe, and everyone else needs to be safe. And so, in short, as I understand it, the question is, where is the less the risk, at school or at home? But ultimately, that's supposed to be a decision for the parents, the guidance says. Everyone working together, but ultimately the parents should decide. Now, if a school is actively refusing to have a child or a young person back, first of all, if they've got an EHC plan, there's an interesting question there about whether the school's complying with Section 43 of the Act, which requires them to admit the child or young person. So, and that hasn't been eased. There's no change to Section 43. So that's the first thing I'd be looking at. Also, are they making reasonable adjustments under the Equality Act if that child has a disability? And are they just acting rationally and reasonably? Is there a good reason why they wouldn't have that child or young person back? But in terms of the remedy, what do families do about it? Again, it's judicial review, because you can make a complaint and that might work. But if it doesn't work, you can't go on to the ombudsman. You can't go to that final step at the moment. So it would be a situation where presumably you'd be looking at whether you can get legal aid for that child or young person to bring a judicial review claim. And in those situations, the parents would act as litigation friends, most likely, and give the instructions to the lawyers, but the legal aid would be available in the child or young person's name.
So it's the parents' view is more important there than what the school thinks about the risk?
I think it depends on what the grounds are for refusal. So if the grounds were solely to do with the individual child or young person, then I think that's right. But if the grounds were wider public safety grounds and the health of all the people in the school, then I can see how the school might just say no. But they've still got to explain how they're complying with their duty under Section 43 of the Children and Families Act in that context, if the child or young person has an EHC plan, of course.
Can I give you an example of something that may very well happen?
Sure.
Where would a parent stand if the school says that they can't provide one-to-one support that is in the it's stated in the educational healthcare plan, but claim it's because of a staff shortage or social needs of sort of social distancing? So they're using the coronavirus as the reason and kind of safety around that. Where would the parent stand in that case?
Well, the first thing to flag, and this often gets lost, is that it's not the school's legal job to make anything in the EHC plan happen. It's the local authority. Now, in practice, of course, schools will often do it and they'll be funded to do it, but the legal remedy is against the local authority. But schools do have another important duty I haven't mentioned yet, which is the duty in Section 66 of the Children and Families Act, again, not affected by coronavirus, which is to use their best endeavours to secure the special educational provision that all children and young people, even those who don't have plans. So certainly school governors can be challenged, or academy proprietors, on the basis they haven't used their best endeavours to make this provision available. But in terms of who has to make the EHC plan happen, it's the local authority. And that duty on the local authority has been eased down to a reasonable endeavours duty at the moment, as we know. And so the question is there anything that could reasonably be done to secure that provision, that one-to-one provision for the child? And it might be, of course, and the guidance strongly anticipates this, that the child doesn't get the provision in exactly the same way as they had it before, but they still get something. So one of the very first things the guidance says is reasonable endeavours doesn't mean do nothing. It means do what's reasonable. So the challenge would be, and I think it's, as always, the onus probably falls on parents to try and be creative and think about what other ways of doing things would be possible, including remote sessions, for example, sessions in the home, sessions in another environment that's deemed to be safer. There's no limit really on what could be done.
I think something that sat quite uncomfortably with parents when the one-to-one support has been funded through, you know, the Education and Healthcare Plan has got it as a provision, it's therefore being funded, the school is accepting the money for that, and yet the one-to-one support hasn't been there sort of like remotely, so they've not seen their one-to-one support there, and you know, there's also the risk that they won't be able to come back because that one-to-one support won't be there, yet schools still either using that one-to-one elsewhere or taking the money for it.
One of the interesting bits about the law is it doesn't really talk about money in this context very much at all. How local authorities and schools fund this system is dealt with by policy guidance that's from a completely different area, the school funding regime. In terms of the legal duties to make provision, it's just very clear the local authority has to make it happen, however they choose to do that. So if a school's been squirreling away money that it hasn't been using on a particular provision for that child, that's really a matter between the school and the local authority. What matters is that the child's getting the provision now, starts to get it now, and in particular when schools reopen, that they get what they're entitled to under their EHC plan at all times. And I think in many cases, reasonable endeavours will mean what is in the plan. You know, the starting point is what's in the plan. And the local authority under the guidance has to explain why it can't do what's in the plan and what else it's going to do. So it has to give a reasoned explanation to the family as to what's being done that's less than in the plan, but is still reasonable. So I definitely would encourage families not to be put off and be told, well, we only have to do what's reasonable. And that might be quite a lot. In fact, it might be everything.
So does judicial review, is this the only answer for things like, for example, if a child isn't getting sufficient remote education, or if they've been told that you can only have a part-time timetable, that's the only recourse?
Legally, yes. Of course, judicial review is a remedy of last resort. And so you have to have tried to sort it out first. And that involves conversations with the people on the ground, people who might be able to make a difference. Ultimately, of course, for schools, it's the governors or the academy proprietor who have responsibility, but you'd also want to be talking to the SENCO, the head, and so on. So you can show that you've tried to sort it out even before you contact lawyers, but don't take too long about it. The point's about needing to move promptly as well. And then before you can go to court, in almost every case, it's not an absolute requirement, but it's a general requirement that you have to send a letter before action. And there's a protocol that sets out what has to be in that letter. And you have to give the public body, including the school, a chance to sort things out, do the right thing. And that's often where these cases get sorted out, is when the letter comes in with the solicitor's headed paper that explains what should be being done and why it's not been done right so far, and has a very clear, you know, list of things that need to be done. Surprisingly enough, that suddenly unlocks things, and the situation moves on. And I should stress as well, some of the charities can help. So SOS SEN, as I understand it, offers a fixed price service to do a letter before action, which might well be more affordable for families as well. Not saying that even that is necessarily affordable for all families, but it might be a more accessible option for more families. Is it worth spending money on these things? Well, it might be, because as I say, what else are you going to do? Ultimately, unless there's a reasoned legal argument, if a local authority or a school is just saying no, you reach the end of the line, don't you? And particularly where you haven't got the ombudsman there to go to be that independent referee of whether there's been maladministration. So,
and the problem is, though, is we're talking about families who are educated, families who have the funds or the know-how to get this done. Most of children who are not getting what they need, their parents just don't know how, don't have time, don't have energy to do that kind of thing.
I'm acutely aware of that, and I'm also particularly conscious of the position of looked after children with SEN as well. You know, whether the local authority is the corporate parent, and they're the ones that aren't providing the support. It's very concerning. What I would say is that I do act for very disadvantaged children and young people as well, where there's an advocate or a parent who has been able to get access to legal aid and access to legal advice. And the legal help scheme, where parents are eligible themselves for legal help, is a way of getting that quick advice, low cost. You know, you won't get a huge amount of hours, but you will get the opportunity to get someone to send a letter on your behalf, and you may potentially get barrister advice as well, and expert reports are available. So it's not that there's no support. The problem is that the threshold for legal aid is set so low that there's a large number of families who can't access legal aid and haven't got the money to pay private fees for lawyers. And that means the system isn't working properly, because if you take away the ombudsman and you leave judicial review as the only remedy, then people need to be able to go to court. So it is genuinely concerning. Also should mention that the solicitor's firm that's recently been set up, Rook Irwin Sweeney, has a social justice fund that you can apply to for some relatively quick, I think, bits of advice and bits of support. So there are these opportunities or options. Are there enough of them? No, definitely not. But I would hope to encourage families to keep trying to get good advice, because if you're put off and discouraged by thinking, well, there's nowhere to go, that's actually not right. And, you know, I spend most of my working day helping families through these kinds of mechanisms.
Can I just ask, we've talked a lot about children with educational healthcare plans, but there'll be a lot of children returning to school who have SEND support, so they don't have that kind of legal recourse. What if a parent didn't feel like their child's needs were being met by school and they're on SEND support? Do they have any kind of comeback at all?
Yeah, it's a very good question, because the reason I don't talk much about SEND support is it's not actually a legal concept. It's in the code of practice. It's a concept, again, a policy concept that comes from the code of practice. The code of practice is statutory guidance, but it's not something you see in the Children and Families Act itself. So as with my lawyer's hat on, my immediate answer to that is, well, yeah, you ask for an EHC needs assessment and you go through that process and get an EHC plan. Of course, we know that the system is not designed that everyone gets an EHC plan. It shouldn't work like that. And the hope is that most children and young people with SEND won't need one. But if you are dissatisfied with the provision that's available in the school or setting, then it is through an EHC plan that you get your legal entitlements, even if at the moment it's not really an entitlement. It's a right to have someone use their reasonable endeavours to make it happen for you. But that's still better than nothing. Yeah. But what can those families do if you're not going for an EHC plan, or if you're early on in the process and you're not happy? Well, then in general terms, the responsibilities are with the school. So you're looking at the Section 66 duty under the Children and Families Act, this duty to use best endeavours to secure provision. And you're saying to the governors or the staff, you know, on behalf of the governors, look, there's more that could be done here. And you're looking at the Equality Act, thinking about issues around reasonable adjustments not having been made, whether there's been indirect discrimination by the application of blanket policies, or discrimination arising from disability, where people are being treated less favourably because of something that's connected to their disability, like their behaviour or the way they communicate. So there are still legal remedies in relation to schools, but you don't really get an awful lot out of Part 3 of the Children and Families Act. Mm. The meat of Part 3 of the Children and Families Act is education, health and care plans. The local offer, the Section 66 duty, these exist for a wider group, but certainly the area of it that occupies most of my time is EHC plans.
Yeah, I think a lot of people are concerned that it's these children that are going to really suffer going back, with resources being limited and teachers being stretched.
I think that's fair, yeah, and with social distancing as well, reducing the space that's available, and schools actually, you know, may well be and feel and be very different things. I mean, I remember seeing the pictures of what the French schools looked like when they went back, and being shocked by what was happening to children in the schools, and the pictures that you were seeing of what social distancing actually means in practice. There's going to be a massive adjustment for everyone, and we've got half a term potentially, or probably not even a full half term, to look at before the summer. I hope that can be used positively to try and find creative and positive solutions, because the real action is going to be September, isn't it? What do the schools look like in September? I don't think that the pandemic will be over by September. There's no evidence that I've seen of that. And so we are in this for the medium to long term. And I think we need to be planning for a very different kind of education system for the rest of this year and possibly beyond. That's what I see.
All the issues around transitions as well for an awful lot of children as well.
We're creating, the virus has created a new transition point for everyone. The school they go back to, I was just talking about this in one of my own cases just this afternoon. The school that young people will go back to, or children will go back to, will probably be a very different thing than what they had before, and that's going to need very careful management and very careful support. What I would stress though is that the needs and interests of children and young people with SEND should be at the top of the list, not at the bottom of the list when we're thinking about how all this works. What Parliament has done over the last 10 years, let's randomly pick the Equality Act as our starting point and then think about the Children and Families Act as well, is say that this cohort of children and young people are a priority. So the public sector equality duty says you've got to look to advance equality of opportunity for disabled children. The Children Act 2004, okay, we've got to go back a bit longer, says that you've got to look to promote the welfare of all children, including disabled children. So, and then you get this whole new scheme for the Children and Families Act as well. And so what I find very concerning is that we still see situations where it feels like disabled children and young people with SEND are at the back of the queue for resources and support. And we'll get to those next when we've sorted out, the non-disabled kids, the ones that are going to get lots of A's in the exams. That's not right. And if that is the attitude that's being taken, that needs to be challenged very hard, I think.
So you said you wanted to touch on social care. You wrote on Special Needs Jungle about direct payments and social care for health and for NEHC plans. What's happening with social care now?
Sure. So let me take social care for children first, and then look at adults. And what I was really pleased to write for you guys was these blog posts about a particular important issue, which was whether direct payments can be used to fund family members to provide care, which seemed at the beginning of the pandemic to be a really pressing issue. And I know for a fact that those posts have been used by families to access that support, which is fantastic.
I used it.
Even better. So the short answer, by the way, don't worry about reading the whole post, is yes. And the test is whether it's necessary. And most local authorities, I think, in my experience, have taken quite a sensible approach to that and are saying, well, if you're locked down, if you're shielding, or if you're in an extremely vulnerable group, then obviously it's necessary because no one else can come in. And that was the short point we're making, but the details are there. But more broadly for children's social care, the key message is that none of the duties that really matter for disabled children have changed at all. For Section 17 of the Children Act 1989, the duties to children in need, Section 20 of that Act, which is about accommodating children in need, including residential breaks, and probably most importantly, my favourite bit of law, most obscure, Section 2 of the Chronically Sick and Disabled Persons Act, the 1970 Act, 50 years old now, which is the duty to secure community-based provision, in short, for disabled children. That hasn't changed either. So you see these very distressing articles. There was one yesterday about families getting no support, no social care support at all. And I'm asking, well, why is that? Because the duties haven't changed. So that is the first message, is that you can still request an assessment. You can still require that to be completed. And if assessment's been done and there's eligible needs identified, then that provision should be made, even if it's made in a different way than it would have been before. There are some important changes around children's social care in terms of regulations that are being challenged by the charity Article 39 and others. And there's a judicial review claim there that I'm involved in. But those are important regulations for looked after children in terms of visiting and planning and other requirements, and some regulations around adoption and fostering as well. They don't touch on these basic duties for disabled children in need. So although they're important, they do things a rather different part of the social care arena than most of our children and young people. So in terms of adult social care, what happened was that when the Coronavirus Act went through, all of the duties, well, it's not quite true, most of the duties under the Care Act were downgraded to powers. And in particular, the duty to meet adults' needs in the Care Act was changed to a duty to meet needs only where it would breach someone's human rights not to. But the very interesting thing that then happened was the Secretary of State published statutory guidance and said to local authorities, don't do any of this unless you absolutely have to, and created a process through the guidance where they have to go through various stages before they use what are described as these easements to the Care Act. And only at the moment 4 local authorities, all in the Midlands, are using the easements, have gone through that process and have told the Department for Health and Social Care and the Care Quality Commission that they are easing their Care Act duties. So the vast majority of local authorities at the moment are saying that they are complying with the Care Act in full. So although it looked really disastrous for disabled people's rights when the easements went through and when the Coronavirus Act went through and attempts to amend that were rejected, in practice, actually, it's only in a very small number of areas where anything has changed in terms of adult social care. And certainly at a policy level, if a local authority hasn't triggered the easements and hasn't gone through that process and reached stage 3, which is the first of 2 stages where they are easing their duties, then nothing should have changed, and they should be doing exactly the same things as they were before. So actually, although adult social care looked like a bit of a disaster zone when the Coronavirus Act went through, as long as local authorities are playing by the rules and sticking to the guidance, actually it's only in 4 local areas that anything's changed at all for now.
If you're in those areas, what can you do?
So if you're in those areas, it depends what's been eased. There's a real issue around transparency, I'd suggest, because different areas are saying that they're disapplying different bits of the Care Act. Really strange situation where the law can change depending on which local authority you live in, but that's how the Coronavirus Act works according to the Secretary of State for Health. And so you need to understand what has changed and whether it's the wholesale disapplication, you're not getting any rights to support at all, or in many areas it seems to be quite modest changes. Or so, for example, in some areas it's just very small packages of home care that are no longer being provided, and in part it's said because people don't want it at the moment. That may or may not be the case, but it's not like everyone's been kicked out of care homes or supported living settings. So the thing to do is to work with a local advocacy organisation or a solicitor if you're concerned that you're not getting the support you need, to understand what the actual changes are. And if your package has changed outside of those, challenge it. And again, the remedy would be judicial review. There's no tribunal for the Care Act. There's no way you can complain to the Ombudsman. So you're going to have to look at judicial review again there as well.
Can I just ask, you're talking about the flexibility with direct payments. Does that flexibility extend to things like how short breaks are used?
Should do, in my view, because obviously packages will have to change as a result of the virus. And so it's really important that local authorities take seriously all the guidance that comes out that says work together with families in terms of sensible replanning of provision to meet the current situation. That might involve using contingency funds or developing a contingency fund. It might involve services being provided in different ways. And the Care Act, certainly for adults, is interesting in the way it's structured because it doesn't require local authorities to provide anything specifically at all. What it requires them to do, unless it's been eased, is meet needs. And they can meet needs in all sorts of different ways. And the whole purpose of that is to make it a partnership and a creative process. And there's a duty to take all practicable steps to agree the care and support plan, working with the disabled person and or the carer. So the short answer, sorry, that's a long lawyer's answer. The short answer to your question, Renata, is yes, should be flexible.
Okay, great. That's brilliant. Well, I have to say that's all we've got time for, Steve. I really want to thank you for your time today, for sparing so much time to explain all this to families. I know it's going to be really useful. Your last video we did had thousands upon thousands of views. So really hope that some of the questions that people have sent in have been answered, and I hope you understand that we did have to kind of anonymize them because some of them were quite quite obvious. But if there's somebody you think that we should be chatting with about SEND issues, do let us know. But for now, Steve Broach, thank you so much.
Great
Thank you,
pleasure.
Steve.
Thanks for having me, guys.